Mediation can be complicated and daunting, but today we're going to walk you through it step by step. My name is Scott Occhiogrosso, and I'm a partner at Block, O'Toole & Murphy. In every case, one of the jobs that we have for any client is we have to try to get the best possible offer to settle the case. We always look at it like we have two sacred duties to a client. We have to prepare the case for trial from day one so that if the case goes to trial, we know that we're prepared to go all the way through and take a verdict on the case. At the same time, we have a duty to get the best offer from the defense, from the insurance companies for the client. Towards that end, mediation is an extremely helpful way and the most effective way to negotiate most personal injury lawsuits. For a client, it's really important that they understand a few things about a mediation. One is that there are many cases where the day of the mediation really begins the conversation in earnest. It doesn't finish the dialogue to get a case settled. And it's really important that clients go into that day with that understanding. Cases can settle at mediation, and if they do, that's a great day for everybody. But just as often, if not more often, you come away from the mediation and you know more about how the other side values the case. You've narrowed the range in what you think is a good number on the case, what the other side thinks is a good number, and you have a real sense of what it will take to get the case done. But it's important that clients understand that in most instances, they have to go into it with sort of sober to that reality, that in most instances, the mediation day doesn't bring the case to final resolution. The thing about a private mediation, as opposed to something that's court-sponsored, is one, the parties select the mediator, which is extremely important and extremely helpful. In most instances, you're dealing with insurance companies, and in the cases that we handle, we're looking to resolve the cases for extremely significant sums of money. The only way you're going to get insurance companies to part with really significant sums of money is if they're working with a mediator that they're comfortable with, somebody that they've resolved cases with in the past, and somebody whose input they welcome and respect. So in a private mediation, we get to agree on a particular mediator with the folks on the other side, both the attorneys and the insurance adjusters. So I think that private mediation gives us the best opportunity to resolve most cases, and that's one of the main reasons. It's the mediator, whoever that person is, has a lot to do with the outcome. The vast majority of the cases can be mediated, and I think it's really, it'd be easier to say what leads you to believe a case can't be mediated. The overwhelming majority can be. It's just a question of timing. Certain things have to be done on the case in most instances before the folks on the other side are willing to sit down and try and mediate a case. And it can be painstaking, and there are many cases that we feel we've done everything that we can to articulate the risk, to provide all of the information about our client's loss of earnings, about our client's injuries, about the cost of the medical care in the future. We've provided an analysis of sustainable value of pain and suffering verdicts for cases with similar injuries. One of the hallmarks of what we do here is we try, and Dan O'Toole, one of the many things that he famously teaches us is you want to spoon feed risk, you don't want to force feed risk. We try, as the case is developing, to provide the other side with the information that they need to provide to the insurance adjusters so that they really understand the significance of the case, and it doesn't come as a surprise to anybody when we send out a claims correspondence that has a $12 or $15 or $20 million demand. Oftentimes we get to that point, we put it in writing and we say we're ready to mediate the case, and it takes a while after that. I think for the same reason. The insurance companies have their processes, and there are meetings that have to be held and different layers of authority before they can go to a mediation where they have significant authority or enough, frankly, to have a real chance of resolving the case. So I think timing is a huge factor in when and if a case can be mediated. a lot of clients are nervous and expect, well, what do I have to do? We always tell clients, you won't speak to anybody at the mediation unless we think it's in your best interest. And that's important because a lot of times the insurance adjusters or the attorneys on the other side do want the client to be present at a mediation and do want a chance to speak to the client, and they need to know that we're protecting them at all times. We always have what we call expectation conversations with clients ahead of time. And the reason is that the negotiation that goes on at a mediation can be a very fluid process. So we need to know where the client stands before that day even starts. We need to know the client is willing to accept X. If we get to this number, the client will take that number to settle the case. You can sit at a mediation for hours and nothing happens, and then you can have 5 or 6 different offers within 10 minutes. And then there are times when the mediator says, look, they'll offer this, but they need to know that it gets the case done, that you'll accept it. So for those reasons, we need to know ahead of time. And we tell every client going into it, look, you tell us what your bottom line is, and we're certainly not going to quit at that number if we get to that number. If the number's realistic. If the number's not realistic, then we need to tell the client that also to adjust their expectations. But if it is something we think we have a chance of accomplishing, then we tell them, look, if we can get more, we're going to keep going. But any offer they make, if they offer $1, we're going to discuss it with you. We promise you that. At the mediation, you're the boss. We're going to talk to you about every single offer, and every step of the way we'll explain to you whether we think this is the number you should take or if we think we should continue negotiating. This is an adversarial system, and every insurance company and every insurance adjuster, I don't say this as a disparaging remark, but their job is to resolve cases for the lowest possible number. The lawyers that represent defendants in these personal injury cases, their job is to help persuade that the case isn't as valuable as the injured person thinks it is, or the injured person's attorney. If somebody were to try and negotiate a case without a really experienced lawyer on their side, without a doubt, they're going to be convinced by experienced insurance adjusters, experienced insurance defense attorneys, that the case is worth way less than what it's actually worth. And if there isn't somebody there who can look these people in the eyes and say, listen, I take verdicts on these cases. I know exactly what the case is worth, and I know exactly how to go get that from a jury, then you're never going to get to what's really fair, and that person's going to be deprived of the justice they deserve for all the suffering they've been through. We are a trial firm, and while we still hold just as sacred our duty to get the best offer on a case for a client, this firm has made its reputation by taking verdicts on the toughest cases and taking the biggest verdicts in New York City for decades now. There's really no bluff involved. If you prepare a case from day one like it's going to trial, and if you're an attorney who's experienced in taking verdicts on really big cases, then when that time comes and you're negotiating a case for the best number, you're the person who won't blink. You're the person who is willing to walk away and say, look, you don't think the case is worth what we say it's worth? One of us is going to be right and one of us is going to be wrong, and I guess we're going to find out in court. And frankly, there's just not a lot of attorneys, not a lot of firms that have the level of expertise and devote the time and resources to preparing cases the way we do. And I think just as important is the commitment to helping people here. And I don't say that there aren't other personal injury lawyers who are just as committed to helping their clients, but I'm doing this here for more than 11 years now, and I know for a fact from the blood, sweat, and tears that I put into it with every other lawyer here, case after case, that the commitment and doing what's right for the client is something that every single one of us is willing to lay down our lives to get done.